being here this evening, our very spirited panelists this evening. I'm going to start with David Frederick. He represents the clients across a broad spectrum, principally in appellate courts. He has argued more than 70 appeals, including 38 in the Supreme Court. He's been at every U.S. Court of Appeals and in all 3 state Supreme Courts. In the Supreme Court, Frederick has represented individuals, investors, immigrants, classes of consumers, farmers, Native Americans, small corporations, trade associations, large companies, foreign governments, and 5 individual states. Frederick graduated from the University of Texas School of Law, University of Oxford, where he was a Rhodes Scholar, and the University of Pittsburgh, where he was a Truman Scholar. He served in the Department of Justice as Assistant to the Solicitor General and as Counselor to the Inspector General. He is the author of 3 books and is a partner of Kellogg, Hubner, Hansen, Todd, Evans, and I think it's Fiegel. Eric Jaffe. Eric Jaffe is an appellate litigator with a practice covering a wide variety of legal issues in both state and federal courts of appeals. A substantial portion of Jaffe's practice focuses on constitutional issues and litigation in the U.S. Supreme Court. He represents individuals, business corporations, nonprofit organizations who are parties in a litigation or who seek to participate as amici curiae in cases representing significant economic, political, and social issues. In 1990, graduate of the Columbia University School of Law, Jaffe was a law clerk to Judge Douglas Ginsburg of the U.S. Court of Appeals for the Washington, D.C. Circuit from 1990 to 91. And following that clerkship, he spent 5 years in litigation practice with the Washington, D.C. law firm of Williams & Connolly. He has been a sole practitioner since 1997. And our deep gratitude from the Dole Institute of Politics goes to Stephen Mcallister, who has helped us plan all of our programs we have had for Constitutional J. And he's our moderator this evening as well. Steve Mcallister is a native Kansan who grew up in Lucas, Kansas. He graduated from the University of Kansas in '85 and from the University of School of Law in '88. And following his graduation from law school, he clerked for Judge Potner of the United States Court of Appeals for the 7th Circuit in Chicago, Illinois, and then for Justice Byron White and Clarence Thomas of the Supreme Court of the United States. In '93, Steve returned to the University of Kansas School of Law as a visiting professor of law. He served as dean of the KU Law School from 2000 to 2005. He won the W.T. Kemper Award for Excellence in Teaching in 1999, and as a scholar, Steve has written on a variety of constitutional topics, including affirmative action, capital punishment, federalism, and sex offender laws. He has also appeared before the Supreme Court of the United States several times. He served as the first state solicitor for Kansas, assisting the Kansas Attorney General's office in state cases raising important constitutional issues. You have before you this evening 3 outstanding panelists, 3 outstanding attorneys. You will hear for the affirmative action, against the affirmative action in terms of our admissions. The moderator will try and keep them on task. We had him at lunch. He's going to have a difficult job. And I hope you will enjoy it. And we will have a question and answer period as we always do. Keep it civil, enjoy it. And this evening, I'm sure you will learn a lot about the Constitution. May I please turn it over to Steve Mcallister, and a round of applause for our guest this evening.
Well, thanks very much, Barbara. It's a real pleasure to do this with 2 outstanding fellows, and I think they will do what the Dole Institute has come to expect, which is engage in a high level and civil discussion, even if spirited, on this controversial topic. I want to start because I assume a lot of our audience may not be constitutional lawyers, so I want to give a little background. I want to give each of them a chance. I think they're going to divide it up. One, speak to exactly what Texas does in its admissions process so we all understand how that works and how race is accounted for. And then one may speak to what the lower courts have done and sort of how this case has come up to the Supreme Court and what posture it arrives at the court. So, David, do you want to start?
Well, I'll kick off by giving a little background to the admissions policy at the University of Texas. But before giving some of the mechanics of how the admissions is done, a little bit of history is in order. The first African-American student was not admitted to the University of Texas until 1950, and that was by virtue of winning a case in the Supreme Court of the United States called Sweat versus Painter. And that person was allowed to be admitted to the University of Texas Law School. As late as 1969, the Texas Constitution provided that blacks and whites, coloreds under the Constitution, would be educated in separate schools. So by the time the 90s rolled around, the University of Texas, as the flagship University of Texas, has dealt with and is dealing with changes, dramatic changes in education policy as it relates to breaking down the vestiges of discrimination and segregation. It applied race as a mechanism to augment the student body, to change it from a situation where blacks and whites were educated separately to a place where they were integrated. But a Fifth Circuit decision called Hopwood struck down the university's race admissions policy, using race as one of the factors to be used in admissions, and that was in the mid-90s. So in response to that, the university stopped using race in its admissions policy, and the effect of that was rather dramatic in terms of what the composition of the student body looked like. In the mid-90s, less than, approximately 15 to 17% of the students were Hispanic or African American. And then by the early 2000s, in a Michigan University of Michigan case, Supreme Court allowed for race to be a factor in admissions. And at that point, the University of Texas altered its admissions policy. In the interim, it had adopted a policy known as the 10% plan. And under this 10% plan, what the university did was to say, if you were a kid at any high school in Texas and you graduated in the top 10% of your class, you were given an automatic admission to the University of Texas. And that ended up having a profound effect on the composition of the student body, because it applied whether it was an inner city school of predominantly black kids in Houston or Dallas, or whether it was a predominantly Hispanic high school down in the Rio Grande Valley or out in El Paso. And so that had an effect on creating diversity at the University of Texas. But after this Michigan policy was upheld by the Supreme Court in the Grutter and Gratz decision, the university kept the 10% plan, but then for kids that were admitted that were outside that 10%, it put into place a factor of using race in a pretty complicated formula that we'll be talking about this evening. But the gist of it was that it took the students' academic factors, and it like SAT score, grades, and the like, and it gave a score for the academic factors. And then it gave the personal factors, which would be the person's background, what extracurricular activities the student was engaged in, what kind of leadership positions, and race, and put it into a package of factors for which it gave a score in conjunction with 2 essays the student wrote. And so these 2 essays and these personal factors became another score. And then they put that score with the academic factors, put it on a grid, and then they figured out which kids would be admitted to the University of Texas. So as a mechanical matter, the process of admissions that is before the Supreme Court, that will be argued next Wednesday in the Supreme Court, has this multi-factor test that goes into whether a student can be admitted to the university, takes into account academic factors as well as personal factors.
I generally agree with all that. The upshot is, you'll have to excuse me, I have a cold. The upshot is that taking lots of things into account, they distill it to a number. If that number's high enough, you get in. It's low enough, you don't. And so whatever role race does or doesn't play, in conjunction with many other things, either it increases your personal score or it doesn't. If it increases your personal score, you have a better chance of getting in. And with that in mind, that would be the only clarification I'd make to the mechanics, and I'm sure we'll debate that. This got challenged. It was upheld in the lower courts, in the Texas courts, and the Fifth Circuit, basically following the Supreme Court's earlier decision in Grutter, the Michigan case that David mentioned. The Fifth Circuit said that it's okay to take race into account as long as you're using it in a what they call a holistic approach, in which race is not the only thing you're taking into account, but it's one of several factors that, in this instance, for example, the several factors that go into your personal achievement score. And that it was sufficiently narrowly tailored to achieve the goal of increasing diversity of underrepresented groups, and they upheld it. The one controversial aspect of the decision upholding it was that it seemed to many people that the court deferred to the judgments of the university about how much diversity one needed, what weight to place on diversity, all the sort of soft academic aspects of how does race fit into the educational mission. And that was a subject of some criticism, including in a dissent in the Fifth Circuit, and eventually it got taken by the Supreme Court. And I'm sure there's more we could talk about, but that's probably enough for now.
Okay, well, that gets us started. So we're all on the same page about the case and what's going on. But first question, why does the Supreme Court take this case, and why now? I mean, it had the Bakke case, 1978, 25 years before it really got seriously into university admissions again. The Michigan case is now 9 years later. Any thoughts or speculation on why they take the case now?
Well, it is great armchair quarterbacking, and predicting what happens in the cert process is one of the great black hole mysteries of the practice of law, because the court gets 8,000 cert petitions every year, and it chooses to take about 80 cases. So whenever you file a cert petition, there's a certain whistling in the wind aspect to whether or not you're going to get the brass ring. I think that the reason why the court felt that this might be the right case to take centered on two elements. One is that the way the majority decided the case turned on, at some level, whether or not it should defer, as Eric put it, to the decisions of the administrators. What the majority said was it took the good faith of the administrators and it gave that a little bit of a deference that softened a concept under the 14th Amendment known as strict scrutiny. What the court has held in many, many, many cases is that if race is taken into account by government in making a decision, that that decision is subject to strict scrutiny. And what the panel seemed to be doing, or at least was alleged to have done by a concurring opinion by Judge Garza, was to be softening this idea of strict scrutiny and not applying it in the way that the Supreme Court had done historically in many race cases. So that was one element. The second element was that when the case was, rehearing was sought before the entire en banc Fifth Circuit, the case had originally been heard by a three-judge panel. Ms. Fisher's counsel petitioned for rehearing en banc. The Fifth Circuit divided, I think the vote was 9-6, on whether to rehear the case en banc, which showed a very sharp division of authority within the Fifth Circuit. And I think that the combination of some perhaps deviation, this will be debated and decided by the court, but some arguable deviation from the strict scrutiny standard and the deference to be given, combined with a very sharp cleavage in a Court of Appeals where the judges were pretty evenly divided, I think probably convinced the court that this was a case to take.
Yeah, I would just say that there were a number of parts of that earlier Michigan decision that we both mentioned that were a little squishy, that were ill-defined, and I think this case went to those factors and gave a lot of deference to the university. So if you already have some poorly defined factors in the legal test, and then you're going to sort of give the university largely a pass on those factors, you might think that you no longer have a judicially enforceable test to stop what you might think is a bad version of affirmative action. And that may have contributed to why they brought it to just clarify what the test is so that future courts can tell where the line is.
I mean, can we talk a little bit about rational basis versus
Sure.
strict scrutiny review? So when the court started to look at racial classifications or policies and laws that were deemed to have either be race neutral or to have a racial component to them, they developed a standard of review for how are we going to look at these various classifications. And if the classification was one that was deemed to be race-based, the court applied what was called strict scrutiny, which almost always meant if they applied strict scrutiny, it was held unconstitutional. And if they said that it was race neutral and it was subject to a rational basis type review, well, there's almost always a rational basis for why government does what it does, because we have, public servants who are doing public service and they're doing what they do, and there's a rational basis for what they do. And so these two concepts of review almost became where the fight was, which classification applies, because if it's strict scrutiny, boom, it's going to get struck down as unconstitutional. If it's rational basis, boom, it gets upheld as constitutional. And so these classifications for review really didn't do that much work analytically, because once the court decided it was strict scrutiny, that was the end of the debate. And so what the Fifth Circuit has done here, and it'll be very interesting to see what the Supreme Court does, is to see, is there any give in this idea of strict scrutiny? Can you look at something with a lot of scrutiny and still find it constitutional? Or does the mere decision to apply strict scrutiny review sound the death knell for the policy?
Now, in fairness, I think it was probably Grutter that took strict scrutiny and made it something less. Because Grutter is one of those few cases that actually survived strict scrutiny, contrary to many people's expectation or understanding of strict scrutiny at the time, let's say. So really, for many of us, Grutter was more of an intermediate scrutiny kind of case, somewhere in between. It wasn't strict, it wasn't the easy one, it wasn't the hard one, it was somewhere in the middle. And this case now may be the chickens coming home to roost on having said, well, we're not really going to apply strict scrutiny. We're going to apply something in between. And now we got to figure out how far in between.
Well, and it's funny that this kind of came up in the way that it did. I remember a case when I was clerking for Justice White, and the issue was whether rational basis review applied to a state's discrimination against an out-of-state corporation. And I said to the justice, well, it's what do you learn in law school? It's rational basis review. It's got to be okay. And he looked at me and he said, but it's still got to be rational. And that was kind of the first clue to me that justices might look at these ideas of rational basis and strict scrutiny as a little bit more of sliding scale rather than just a one-way ratchet, one way or the other.
Well, let's talk, you mentioned several times the Michigan case, so let's take and it was actually two, of course, is the undergraduate system struck down, the law school system upheld. But do you view this case as likely to be an application, a refinement of those cases? Is there any possibility it's a reversal, that the dissenters in the Michigan case might prevail, say on a colorblind constitution, we shouldn't be doing this at all? How do you speculate how this might play out and how important or not this case might turn out to be?
I don't find it particularly likely that there will be an outright reversal of Grutter. So there will be a couple of justices, I suspect, who take the strong colorblind version of things and continue to advocate that. But my best prediction, which is to say as good as the tea leaf reader in the house next door, is that they will reverse the decision below. They will narrow the scope of the previous Grutter decision without openly overruling anything in it. They'll basically describe it as a clarification and a narrowing to make it a little tighter, a little tougher, and the outcome will be a reversal, but nothing overly dramatic in terms of the doctrine or the law or the jurisprudence?
I think one of the interesting dynamics about this case is that it'll be argued to an 8-justice court, not a 9-justice court, because Justice Kagan is recused in the case. And one of the principal gambits by the University of Texas here is to appeal in as overt a way as one would ever see for Justice Kennedy's vote. Justice Kennedy dissented in the Grutter and Gratz cases with a list of concerns that he expressed for what was problematic to him about what the University of Michigan was doing. And the University of Texas brief is this, from the very outset, a laundry list of, well, Justice Kennedy found this problem with the University of Michigan, but we're not doing it that way. And he found this problem with the University of Michigan, and we're not doing it that way. And so what effect that will have, I think, is going to be fascinating to see, because he will have to wrestle with the nuances and the distinctions and the subtleties that the University of Texas is trying to put forward. And then, of course, we've got new justices who take the place of Chief Justice Rehnquist and Justice O'Connor in Chief Justice Roberts and Justice Alito, and to see how they react to these various arguments. But the fact that it's an 8-member court means that if it ends in a 4-4 tie, then the Fifth Circuit opinion will be affirmed. And so it would be a 5-3 at the very least in order to reverse the Fifth Circuit.
Now, as a practical matter, this is the same dynamic even if there were 9 justices, because it's Kennedy's vote that ends up deciding it one way or the other. So either he joins his 4 more conservative colleagues and provides a 5-vote majority, or he now joins his 3 more liberal colleagues to create a tie, but a tie goes to the current victor, and so it's not quite like affirming the decision below, because it doesn't have the same precedential value, but it does lead to the same result as if he were joining 4 people on the left rather than just 3 people on the left. Is Texas at least lives to fight another day on this issue, though it won't have the same long-term effect.
Okay, well, so talking about some of the players, two sort of pieces to this question. One, does it make a difference that there is, in essence, a trade of Chief Justice Roberts for Chief Justice Rehnquist, Justice Alito for Justice O'Connor, who, after all, wrote Grutter and really seemed to be the driving force behind that opinion? That's one question. Then I'd like you both, for the audience, to spin out a little bit the views that are represented. We've mentioned briefly the colorblind. So who would be the strongest defender of the colorblind Constitution? Who would be the strongest defender of something less than strict scrutiny? And how might that play out in a series of opinions we might see in this case?
I do think that the changing composition of the court will have a significant effect on this case. My read of their opinions is that Justice Alito approaches these questions of race very differently, or different enough than Justice O'Connor did, that he's likely to be skeptical of what the University of Texas was attempting to do here. And Chief Justice Roberts, notwithstanding the fact that he's a former law clerk to Chief Justice Rehnquist, I think also approaches these questions differently than Chief Justice Rehnquist did, and it may be a difference in their time and place and where they grew up and what they experienced, but I think the best indication of where Chief Justice Roberts might be on these issues is a case decided 5 or 6 years ago involving Louisville and Seattle schools and what to do about diversity in public school composition. And in that case, Chief Justice Roberts wrote very passionately about a colorblind society, about not using race, about the best way of stopping discrimination, he wrote, was to stop discriminating. And it was a very impassioned appeal, I think, for people not to use race in the way they make decisions in their dealings with other people. And that, I think, spoke very powerfully about where he feels about this. But that, to me, signals that he may well be skeptical that even though what the university is describing its action is using race as a factor of a factor of a factor of a factor, rather than the factor, that he's still likely, I think, to be skeptical of using it in that way.
I think that's right. I think Kennedy, though, is a little more uncertain. At times, he has spoke very passionately himself about his sort of dislike for the use of race. At other times, he seems more accepting of the need to use race to create diversity. And it's just hard to know which way he'll come out this time. It just depends on the facts of the case and how they strike him, reasonable or otherwise. One question you asked is who's likely to be the most passionate defender of a colorblind society? I think that's easy. Our former boss, Justice Thomas, is clearly going to be the one who's least accepting of the use of race in any of these circumstances. I suspect Justice Ginsburg will be the most accepting. I just don't know whether Sotomayor, well, Kagan's recused. It's hard to say what Sotomayor's views on this is. I think she will be reasonably accepting as well, given her decision in the Second Circuit in the firefighters case. But overall, I'd say Ginsburg is probably the strongest proponent, maybe Breyer, but probably Ginsburg more than Breyer. We'll see. I think all of them are a little disturbed by the notion of classifying students based on their race, which is why you get all this talk about holistic reviews and a factor of a factor of a factor. It's an attempt to push it back, to push it further away, to make it less decisive so that it's not the primary thing you're defining a student by. And at some intuitive level, I suppose that's good. But at the end of the day, race makes a difference. The use of race in these kinds of programs, either it makes a difference or it doesn't. Either it lets more kids in of the race that you're trying to get more of, or it doesn't. If it doesn't, everybody's wasting their time. If it does, then we should debate about whether it's good or bad, because the university thinks it's a good thing to get more diversity. Other people think it's a bad thing to get that diversity by means of race. Diversity is great, just not racial diversity. Let diversity come as it will. But let's not talk about whether we hit it well enough. The real answer is, should we use it or shouldn't we? And then let's be candid about it.
That's a great, can I lead into a next question?
Sure.
And then you can take it wherever you want. Tell the audience, each of you have written a brief in the case and filed on behalf of interest. And so talk a little bit about your client, why they were interested in the case and their positions, which are starting to come out here, I think, in the discussion, why they either favor or disfavor the Texas system.
Well, I wrote a brief on behalf of distinguished alumni of the University of Texas who represented leadership positions throughout the state, political, medical, educational, in the legal profession, engineering, business, the like. And their principal orientation was that the University of Texas serves as the flagship university for the paths to leadership throughout the state. And because Texas is a state with very complex, ever-changing demographics, it's important that the university be in a position to train future leaders of the state and the nation who are able to understand how to deal with those complicated demographic environments. And I'll just step back for a little bit. Texas is an enormously wonderful place. It was where I grew up, and I went to law school there. But when I was in law school there in the 80s, there were black kids that were pulled behind cars and killed by virtue of being pulled in chains behind cars in East Texas. And it's a state that has had lingering issues of rampant and difficult and pernicious and evil racism. And I think what the leaders and the distinguished alumni that I represented wanted to convince the court of is that although Texas has made many strides from 1950 when Heman Sweat had to sue to the Supreme Court of the United States to get a seat at the law school and become the first African-American student admitted to the university, was that the state still needs to do a little bit more to try to have its flagship university be a place and an environment where future leaders of all backgrounds can get their education and be prepared to serve in a state where in 20 years or 30 years, or by the time the kids that are coming in now are my age, the demographics of the state are going to be very, very different than they are today.
So I wrote a brief for the Asian American Legal Foundation, which was formed to protect the civil rights and defend the civil rights of Asians. It started up in San Francisco. For those of you with any familiarity with San Francisco, they have a long and bitter history of discrimination against Asians, going back to segregation in the schools. Some of the earliest applications of Plessy versus Ferguson were actually at Chinese schools in San Francisco. They wouldn't let them into the white schools. More recently, at least in some circles, Asians have started to be viewed more favorably than they were viewed in the 1800s. Now they're viewed as a model minority. It's just another stereotype that in some ways is equally damaging to those Asians who are not the super performing math geeks that apparently everyone seems to think they are. Anyway, so what my folks wanted me to write, what I wrote, and what I agree with, is that we should be a colorblind society, that judging people based on their race is just wrong. It's wrong, it's damaging, and it's self-perpetuating. And whether you're judging them in a favorable way or an unfavorable way, at the end of the day, we should remove it from the table. And they gave some good examples of how, under many affirmative action plans, Asian students need to score hundreds of points more than their peers to get into these schools, because for better or ill, you have a lot of Asian students performing very well on their tests and on their grades. And so what you end up having is, while you have a lot of Asian students in the schools, it's far fewer than might otherwise be there if you just took race off the table and stopped asking about race. I'm sympathetic to many of the things David talked about, actually, about the need for people to be sensitive to a multicultural society, to be prepared to deal with a multicultural society. I think we may just disagree on how to get there. I don't think you need to be Hispanic to lead and be sensitive to Hispanics, or Asian to be lead and be sensitive to Asians, any more than you needed to be white to lead white soldiers in the army. I just don't think that's the right approach. I would like to educate folks to deal with multiculturalism. I just don't think you have to do it by picking people on race. In an earlier discussion of this issue, I had half facetiously suggested that at the end of the day, you should set a grade cutoff for the type of school you want to have, a B+ average, and then we're going to have a lottery. And the lottery, to the extent that your population is diverse, the lottery will randomly select. So it won't be the top, it won't be the bottom, but hopefully it will be as diverse as your pool is. And the pool being anyone at least reasonably capable of surviving the school. And I know that trades off with lots of things universities want to do. They want to be the best, they want to have a football team, they want to have a band. But at the end of the day, if we really thought this was compelling, if this was the overwhelming need of our society and our primary concern, a true compelling interest in the legal sense, these other concerns don't weigh as much. And so you're right, you sacrifice something, you get diversity, but at least you're not doing it by categorizing people according to their race, is sort of my feeling about it.
So, you know, the University of Texas band prides itself as being the show band of the Southwest. The idea of having 200 trombonists and no other instruments seems a little bit crazy. I mean, you have to make differentiations in order to create the kind of environment at a university of, you know, people of different interests and abilities.
Priorities, I agree. I'm just not sure the band is the priority over racial classifications.
No, it was a tweak at the idea of a lottery.
No, but I said it slightly facetiously, because of course no school would do that. But the point of it was not that they will do it, it merely shows you where in the spectrum of priorities diversity lies. It's important, but it's not important enough to mess up the band. And it's certainly not important enough to mess up the football team or the hockey team or the basketball team, right? God forbid we do that. So we should have some sense of, yeah, we all talk a good game, but nobody really means it.
Well, that sort of highlights, you've talked about strict scrutiny, and now you're kind of getting into the justifications for these sort of programs. Let's talk about that a little bit. The typical strict scrutiny formulation, as David described it, you'd have a compelling governmental interest, and then you'd have narrow tailoring or least restrictive means of achieving that. Talk about your views on, does the university have a compelling interest here, and is this a narrowly tailored or an appropriately tailored way to try to achieve whatever that interest is?
So I think that the university does have a compelling interest for some of the reasons that I outlined in wanting to have a student body that is reflective of the state, that's capable of leading in the state, that has the range of interests to create a dynamic university environment. Now, the question of whether this particular application of the admissions policy fully addresses that compelling interest is a question that we could debate, because one of the things that the state notes about the Ms. Fisher's argument is that it both complains that it's sort of the Goldilocks principle. It's both too hot and too cold. It has such a profound effect of putting race on the thumb on the scales, but then in fact it's really such a marginal interest that it doesn't really have any effect. And goes to Eric's point that if this is really affecting the composition, shouldn't we be talking about this more openly? And I think that the university has successfully pointed out some contradictions in Ms. Fisher's point. But the idea about narrow tailoring is a very tricky one, because the whole idea is that we want government to put as little thumb on the scale as possible when it's addressing these questions where we're dealing with what are known in the constitutional law doctrine as suspect classifications. And these are things that are well familiar to you. Are you a woman? Are you a person of color? Are you and the like? And so, I think that the really interesting question here is what the university doing the narrowest way that it can try to do race, assuming race can be taken into account at all? And I think that there are pretty good arguments for why this is a pretty modest type effort to put a thumb on the scale. Or is there something even narrower that could be done that would have any effect at all? And if you look at the data on admissions, this particular policy has not really affected in a significant way. It's affected some, but we're talking about in the hundreds of admittees where you're talking about a university, over 50,000 students. And so it's not a huge effect. I think it is narrowly tailored. I'm not sure that at the end of the day it really does. If you believe the arguments about compelling interest, this seems like a very delicate dance that's being done.
Yeah, it's interesting. The Goldilocks principle, it works both ways, right? Because if it's so important to get diversity, but our use of race is only getting us this tiny fraction of a % more diversity, well, then why in the world are we using race at all? Either get the diversity or don't. So both sides are playing the same dance in opposite directions. Fisher's saying you use it too much, but you don't get anything out of it. They say we don't use it very much, but we get a lot out of it. It's the same dance, and it's neither one of their faults. It's all the Supreme Court's fault. It's all Gruder's fault for just basically encouraging us to lie about how much we use race, instead of just saying, yeah, we use race, and it counts a lot because we need a lot of people, or we need a few people, so it counts a little. Gruder asks you to bury it, and so I don't think it's either side's fault, but it's both of them are doing this dance, and it's one of the things that disturbs me about it. As you can tell, I don't think racial diversity is a compelling interest. I think it's important. I think it's nice. I think it's good for universities to be diverse in lots of ways. I don't think it is a compelling interest in the way that term is used legally. I think it is a compelling interest not to reveal the location of our troop carriers to an enemy. I think that is compelling because someone will drop a bomb on a ship and kill them all. I think it is compelling interest to tell people not to falsely shout fire in a theater, because if you do, people will be trampled to death for no reason. I don't think it is compelling to have some fractional addition to racial diversity rather than individual diversity, taking into account all the interesting things about you other than race.
But those things are taken into account in the admissions policy of the university, because they're looking at
Of course they are, yeah.
where the student came from, what his or her personal circumstances are, what a family circumstances, what the person has overcome to get to a place to be considered for admission. So these other factors do play into the personal, what they call a personal achievement score, which seems kind of a funny way to, I mean, the nomenclature of it is kind of funny. But the idea of a great university, which the University of Texas is and aspires always to be, is to be a place where the finest minds of all backgrounds can come together, can synergize with each other. I mean, we learn in college as much or more from our fellow students as we do from our professors. And I think what the University of Texas recognizes is that having a student body of kids that are getting together, they're arguing over coffee, and talking about ideas is the best way to create a learning environment.
You know, it's interesting. So I agree with all these other factors for diversity. I like having tuba players and flute players and hockey players and kids who traveled and kids who didn't. All of that's great, and it leads to that wonderful learning environment. The only question here is whether the marginal difference of also layering race on top of that, A, improves the university's greatness by any meaningful degree, and B, is worth the generally offensive notion of categorizing people by race. And for me, it's all about the margins. It's, yes, they take into account 100 things, and they can still do that after this case, even if we say no to race. They'll still take into account 99 things, just not race. And so, to me, the one other thing I guess I'd say is, my views are a function of government, by the way, right? So if this were a private think tank that said, I want to have a think tank with 5 blacks, 5 whites, 5 Hispanics, and 5 Asians, and we're going to pick 5 people, we have a quota, okay, that's good, I'm okay with that. It's a private group. My problem is with the government using race, and at some level, it is a deep suspicion and hostility towards the very notion of concentrated power in government and the political reverberations that using race creates in terms of the incentives to then have racial politics and the incentives to have what some people have called a racial spoils system. So keep in mind that if this were a truly private university, okay, I wouldn't be having this fight. My problem is when it's a government doing it, and the fact the government wants to be the jewel in the crown, I'm not horribly sympathetic to that. It's a good thing, it's nice, it's not compelling, it's just nice.
Where I take a difference from Eric on this is that government supported segregation for decades in our country, and we had in parts of the Deep South particularly state-sponsored, government-sponsored and funded universities that were wholly white and they were wholly black. And when I was a law clerk the same year that Steve and I were up there, the court had the first case since Brown against Board of Education involving the desegregation of university system, University of Mississippi system, which its flagship white universities were 98% white, and their flagship historically black universities were 99% black. And the court was really confronted with this conundrum of people go to college choosing which institution they want to go to. The state provides funding for a public institution. We have a situation here decades after Brown against Board of Education struck down de jure segregation, in which there is still segregation. What does the Constitution of our great country say about that? And the court struggled with that case and ended up sending the case back saying that Mississippi had not done enough to eliminate segregation. But I think that the university setting, as Eric points out, is one of the hardest places of dealing with this idea of governmental issues with race, precisely because it intersects with the concept of a young person's choice about what place to get an education in higher learning. And so that intersection between free choice and government sponsorship of the opportunities that are provided, I think creates special dilemmas and responsibilities for people that are concerned about how the Constitution applies in that setting.
So you know, there's an interesting line of cases that talk about the situation like the Mississippi University, where a government institution has a long and lingering history of discrimination, and sometimes the steps you need to take to get rid of that, to wipe away the effects of that, will have to be race conscious. You can't say you refuse to let any black people in without saying the word black person. You got to fix it first before you can get back to neutral. And there are lots of cases that stand for the okayness of that. This is not that case. I know there are people who think that this is or should be, but it is not the way the university itself is defending its policy. They're not claiming this is required to fix past wrongs. They're claiming it's just the way we want to educate people today. They're making a different argument for it that has traditionally been dealt with differently at the court.
That's mostly right, but there's a key part in which it's not right. And the way it's not right is that if you go into parts of African American communities in Texas where grandparents and parents are telling their children don't apply to the University of Texas, that's a place where a black kid couldn't go. That still lingers. That is part of the way that ideas get communicated from among family members, and that affects admissions. And it is a reality. There's an amicus brief on that topic in this case to try to communicate to the court that these issues of suspicion, concern, attitude are still prevalent. And how we get past that and break that down is subject for another panel discussion, but it is still real, and it is part of the thing that the university has to grapple with, and they understand that as a problem.
I'm just not sure that the answer to that is to now have all the Chinese parents and the Vietnamese parents saying to their kids, don't apply because you'll need to score 300 points higher in order to get in than anyone else. If we discriminate because people think there's discrimination, so you discriminate the other way to convince them that it's not there, it just means somebody else is being discriminated against. If at the end of the day, don't discriminate against anybody and make sure every community, white, Hispanic, Asian, Chinese, Vietnamese, whatever it is, understand that the doors are open, that your color won't stop you, it won't help you, but it won't stop you. But I just don't see that it helps to, now, I mean, I have Chinese parents and Chinese students who all think that they're discriminated against at schools like Berkeley before California changed the rules, and at places like Texas, that they'll have a harder time getting in, and they're just going to apply somewhere else because they don't want to be discriminated against. It may not be true, but that's certainly the message we're sending.
This brings us to a point that occurs to me. You mentioned the Seattle and the Louisville cases and the Chief Justice's impassioned plea to the way to stop discriminating is to stop discriminating. And there's an argument in that case between, I believe, him and maybe Justice Stevens or Justice Breyer about Brown, which of course is close to home. So with Justice Breyer and the meaning of Brown, and I wonder if you'd both just, we're going to turn it to audience questions here in a moment, so be ready if you have questions. But does Brown tell us anything about affirmative action and the way we should view these efforts today? Because that was their argument, two very different readings of what Brown really means for this kind of a setting.
I would say that what Brown stands for is a very complex and set of wonderful aspirational values that our Constitution upholds that are not maybe particularized in words other than in the Equal Protection Clause, but the basic concept that separation by race is not how we want to govern ourselves as a society. And precisely because, as a matter of law, Brown kind of sort of elevates itself above the norm of the way law is decided here. It is always in the background, I think, in these questions, and it speaks to us and our aspirations in the same way I think it speaks to Eric and his impassioned plea about how we should govern ourselves. It speaks to me about the power of government to help right past wrongs and to help ensure that we get to a better place, even if it can't answer some of the more specific questions and problems that we're facing here in the 21st century.
For me, Brown has always been an interesting conundrum in very much the way I think David described it, is that it's a rule and then it's a remedy. The rule is this high aspiration for how we should be. The remedy is trying to apply that aspiration to the nastiness that is the real world. And those two don't share the same space. They don't share the same head space. They don't share the same physical space. They don't share the same intellectual space. They're two very different things. And I'm always troubled by the remedy and happy with the rule. And it's not clear to me that I could have come up with a better answer. I understand it's a hard problem, particularly at the time of Brown. But in terms of lessons to be drawn from it, I wish the lessons to be drawn from it is that we never have to make such difficult choices about how to fix something broken again, and let's just try to not break it as much.
So can I just return to the Louisville situation? Because I think what really had Justice Breyer so upset in that case was that Louisville was one of the school districts that had been ordered under Brown to integrate and to stop segregating. And so over a decades-long period, the Louisville system had gotten to a place where it had achieved a pretty good grounding in the community as to how to have kids of different races at different high schools. And so the question in the case was, in Justice Breyer's view, was Brown orders this school system to be desegregated, and now the question is, are the things that Brown's essentially compelled to be done on the basis of race, or do they still need to be done? And so to have Brown invoked to stop the remedies, as Eric put, struck Justice Breyer, I think, as an incredible turning of a great decision on its head. And that was my read on his dissent, why he found that one particularly upsetting.
Well, and I imagine he'll have the same reaction to Grutter in 20 years. Brown never envisioned its solution would be permanent, just as I think Grutter, Justice O'Connor, didn't envision affirmative action would be permanent. She said 25 years and maybe we'll be done. But in 25 years, Justice Breyer or someone taking his role will be offended by the notion that you would cite this case that was a support of affirmative action as now it's time to be done with it. So both cases have a tension in them, is that they offer a solution that is both trying to get to a good place, but is in itself troublesome. And so, we see in them what we want. Some people see the aspirations, some people see the other side. I don't fault Justice Breyer for having given his gloss on the Rorschach test that is Brown, or Grutter for that matter, but at the end of the day, these are multifaceted cases that sort of invite that kind of see what you like, ignore the rest.
All right, well, I think we can turn to audience questions if you have any at this point. Anybody, if you have a question, there's microphones up here.
Hi, thanks a lot for talking today. I was curious, I'm sure you're both well aware of the URM designation for grad school applications, where underrepresented minorities get a very considerable advantage in the application process. And I was kind of curious if this case were to be overturned, what that would incur for the URM designation and grad school application process, and if it does, in fact, have any immediate effects.
I assume for public schools with graduate programs, it would make it difficult for them to use that designation in any way. I don't imagine, well, maybe for private schools, though that's a closer call.
It's a good question, and I'm not sure I've got a good answer, except to say that the way the Supreme Court generally works is in more incremental steps. And so things like that designation, how it's used, what it's done, what role it plays in admissions for graduate school is not directly before the court. And the normal way that the court would address something like that would be not to say something about it, and it is the follow-on litigation of how you apply the Fisher rule in that kind of situation that would get litigated and decided. And it may not be for another 5 or 10 years how something like that would happen.
Well, just to give you an example, after Grutter, many universities, Texas in particular, read the opinion and said, okay, here's our marching orders. We can do X, we can't do Y. So let's structure our programs accordingly. If Fisher, this new case, comes out and says, okay, you have new marching orders. You can do X plus 1, you can't do Y minus 1. Presumably, all schools will read it and being in an effort to be faithful to the rules laid out before them, will conform or try to conform as best they can. And yes, there will be litigation to see how well they succeeded or didn't. But it will have some, not a legal effect right away, but it will certainly have an effect on the thinking of admissions officers in schools.
All right, so during my senior year of high school, 4 of my friends applied to Stanford University, and the first one was number 2 in our class, and he was a Caucasian male, and he got deferred and ultimately rejected from Stanford. 2 people who were number 6 and number 7 were both white females, and they both got rejected. And then one of my friends, who was number 13 in our class, but happened to be Mexican-American, not only got accepted, but got a really good scholarship to go to Stanford. So the people who got rejected first were like, okay, the only reason why this guy got in and we didn't was because of his race. The only reason why he's going is because he's Mexican-American. And one of the downsides to affirmative action is that whenever a minority achieves any success, a lot of people will just say oh, it's because of the leg up that they got because of affirmative action. And they completely dismissed all the other factors that went into it, like the things he was involved in, like his personality, because it's more than just grades and test scores, obviously. But do you think there will ever be a time where we can keep affirmative action and keep the policies, but not have people from the majority populations believe that any minority that has success, it's all because of what affirmative action did for them? Or do you think it'll always just kind of be like an asterisk next to people who have benefit from the entire policies in the process?
It'll always be an asterisk. It will always be an asterisk unless a person can prove to all those around them that they hid their race on their application and made sure nobody knew. It will always be a question mark. I work for one of the greatest justices ever, I think. That's my opinion, but there is always an asterisk next to his name. It drives me nuts. I have, my niece is a Latino female. She's a straight A student. She has grades that make mine look like a joke. Yet there will be an asterisk when she goes to UCLA. There shouldn't be. She's brilliant. But somebody, somewhere, will look and say, well, I wonder. So it's one of the things I don't like about it. I'd rather it just be blind admissions.
I think that there will be improvement on that as greater understanding of how complex and difficult university admissions is done. One of my best friends is the provost of Princeton, and he told me that they could fill their entering freshman class with people with 4.0s and perfect SAT scores. So, you get one problem wrong on the SAT, under that standard, you would not be eligible for admission to Princeton University. And they choose not to fill their freshman class with people with perfect academic records because they want to have a university environment that has people with a range of different backgrounds. And so, I don't subscribe to the notion of the asterisk because that accepts a notion of victimization. And I don't think that's how we should approach life, and I don't think that's how we should approach dealing with each other. I do think that when we have a situation where it's now so easy to apply to colleges because of the common application and because of the computerization, and it's relatively low cost to apply to 20 schools as opposed to 3 or 4, that we've spiraled the complexity of the college admission system way out, and that it is virtually impossible in any rational, mechanical way to distinguish between the number 2 and the number 4 and the number 13 people in your class. And so I think that we get beyond that by honoring each other's achievements and moving forward and working hard to do what we do to add value to how we live our lives.
The only thing I'd add to that is we get beyond it by stop saying that race matters. Because all of what David said is true. There are lots of reasons to let in a wide and diverse group of people. Number 1 is not always the first choice for college. Number 13 or number 16 or number 50 might be a better fit for a lot of reasons. But when the college stands up and says, and by the way, I took race into account and it got me more students, so it mattered, well then it's hardly surprising that other people assume, rightly or wrongly, that it mattered.
Interesting when you take a look at a philosophical perspective. We talk about the concept of colorblind, and I'm all for the concept of colorblind. And you take a look at the Supreme Court making decisions based on colorblindness, and that is a philosophical standpoint. But realistically, in every single poll I've ever seen, and I've seen numerous polls, for people of color in this society, race does matter. So how do we balance the colorblind perspective of the Supreme Court, if that's the way they're going to go, with the reality of people of color that are living in the society from an educational, from an economic, from a political, from a social, and from a cultural perspective? All the numbers, all the statistics indicate that in society today, in 2012, race does indeed matter.
Well, let me say 2 things. One, certainly as a statistical matter, I agree with you. There are very strong correlations with race and a variety of things. I don't say that race doesn't matter as a factual question. My position is that in government, I would like to force government not to look at it, even if it does matter. I'm willing to sacrifice some efficiency, some benefit, some reality, if you will, for the sake of what I think is a very bad tool in government's hands. So you're right. In a day-to-day interaction, I'd like my kid to meet people of different race, just because they're of a different race. And I'd like her to have that experience. It matters to me. It's a problem with government and authority and power that leads to where I go, not some notion that I deny reality.
I believe in government of the people, by the people, and for the people. And so what the people think and what they believe matters to me.
And I believe in a republic, where what the people think and believe, particularly at any given moment, does not matter as much to me as broader principles that operate over 50, 100, 200-year time frames.
I think that it seems like to me that everyone up there is in agreement that what you really want at the end game is diversity in schools, one way or the other. And I think that part of that, you've talked a lot about history of race. There's a racial story that goes on, and that is such a part of American fabric. I think that it tells a story, and that creates diversity on its own. I think that, like your perspective, I'm not really quite certain that that's the answer, because what you're really asking is if we're going to be a colorblind society, what you really want is for those racial stories and the way that the schools are today as they are to be completely forgotten and to start over from scratch. And I'm not quite sure, because you say, I mean, you said,
That's not
like,
what I want, though.
but
I just don't want the schools to take it into account. I like the fact that students take pride in their history and background and want to convey that history to others and want to provide that information. And I like all of that. I like clubs that are, you know, the Black Students Association, the Jewish Students Association, the Asian Students Association. We should take pride in our history and our ethnicity. I don't want government making decisions based on these things. It's a very different, and maybe it's an overly subtle point, but my notion of the Constitution is it's a document that is designed to check the evil tendencies of people when given power. It doesn't assume they're always evil. It doesn't assume they're always good. It assumes that they have great capacity for evil when given power, and we need to provide checks and balances. And one of those checks, in my opinion, is stopping them from using race. Because historically, when we use race, somebody loses badly. And it may change over time, but somebody loses badly because it's the race you don't like, or it's the race that has the least political clout, or whatever.
You know, we put in the 14th Amendment, we fought a civil war over that, to have equal protection of the law, precisely because the Constitution, as it was originally formulated, had a 3/5 rule for persons who were slaves. I mean, I don't think we can ignore our history. And I think those stories that you mentioned are part of the fabric of our nation. Our ability to talk about it, our ability to grapple with it, I think makes us the greatest nation in the world. But it doesn't mean that we are where we need to be. And the whole idea behind the preamble to form a more perfect union, I think is part of what we all are working with, and why, you know, I'm honored and pleased to be part of this conversation with you, because we all need to talk about this more.
Both of you said that diversity on college campuses is a good thing, and I agree as well. But if affirmative action isn't used, what other methods would you guys suggest to increase diversity on state and private campuses?
So I did not say that racial diversity is required, though I do think it's a good thing. I said diversity of all sorts. I want poor kids, I want rich kids, I want kids who worked hard, I want kids who are total geeks, I want sports players. That kind of diversity, obviously, there's no constitutional issue with any of those characteristics. So it's very simple. You do what colleges already do, very holistic view, and I'm not objecting to that. I was quite serious that you could get racial diversity with a lottery. You would sacrifice a lot of other things, but you'd get a lot of diversity, and it would change every year. So it would be a varied and fluxing environment. You'd lose stability. You'd lose the ability to predict if you could have a good football team this year, or if you could have enough kids in the pre-med program. You'd lose a lot, and I'm not sure it's worth it. But you know, there are things you could do. But if the question is how can you get racial diversity without focusing on race, I think you have to look back earlier and say, let's fix the things that are causing there to be a weird applicant pool, dispersion in the applicant pool. Let's fix K through 12, and then there won't be such a big gap in the test scores that we have to worry about fixing by taking other things into account. I'd go back to the beginning, fix it there, and let the end sort itself out. And even then, I wouldn't do it because of race. I'd try to fix all the bad schools. Whatever race you are, get them all better.
Yeah, I mean, you know, here's where maybe my brass tack realism and my conservatism shine through, because with all due respect to Eric, he's talking about completely, radically changing our society, our economic system, our patterns of where we live, our historical issues of where business located. You know, that notion, if we were going to start from scratch and on January 1st, 2013, put all 300 million Americans in a jumble pile and just start drawing names and saying, here's where you get to live and what job you get to have. That's one thing, but that's just not our society. And so, the problem that you put your finger on is if we can't take race into account, at least at some level, how do we achieve diversity? Gets you to something that's very mechanical, like the 10% law that Texas has, which achieved some diversity, although it slid back in percentage terms, if you look at the numbers, from where the composition of the university had been in the mid-90s before Hopwood struck down the admissions policy. And so whether or not a 10% plan would work in Kansas, I have no idea because I don't know anything about the demographics of the state. But things like that are race neutral at one level, although they have effects depending on residential patterns and where people were able to get jobs at certain points in their family history and where they decided they wanted to worship together and live near their church. And all sorts of factors like that which go into the organic fabric of what we are as a society. And those are not easily changed overnight. They're not easily changed over multi-decades. And that's why I think that there is, Eric and I have a fundamental disagreement about that because I grew up in Texas. I was in a majority-minority high school. And that's my background. We're all prisoners of our past, right? But that's mine.
Well, ironically, I grew up in the South Bronx, and I was the only person of my race in my elementary school. Literally, the only person of my race. But we just took different lessons from that, I guess. I wouldn't change residential patterns. I wouldn't change all those other things. I'm radical, but I'm not quite that radical. I would just make sure that the German neighborhood and the Hispanic neighborhood and the Polish neighborhood and the Italian neighborhood and the Vietnamese neighborhood and the black neighborhood all had good schools, and that if they wanted to go to the school in the other neighborhood, they could. They don't have to. I don't want to force them there. But if they want to go to the other neighborhood because they think they want their, if the parent thinks, I'd rather have my kids hanging with the German kids or the Polish kids, or I'd rather have my kids hanging with the black kids and the Hispanic kids, great. I'm more of freedom at that level. I just want the choices to all rise up and be decent choices, whichever neighborhood you're in. And then I'd let it play out as it will. And some places will be diverse and some places won't. There will be differences. Natural, cultural, coincidental differences. Some people may prefer social work. Some people may prefer engineering. I'm not willing to say it's racism just because our backgrounds, our histories lead us into different careers.
Okay, I'm going to give you each a chance just to conclude for a minute or two if there's anything you'd like to say. We're approaching 9 o'clock, and I'm sure these fellows would be willing to stay for a few minutes if anybody wants to come up and chat a little more, but let you close, and then we'll thank you for your participation this evening.
I think I've sort of harangued you enough. Yeah, I think my sort of view is pretty clear. I don't trust government. I certainly don't trust government with a tool like race. I don't like what it does to our political process. So notwithstanding the fact that, yes, race still means something in our society, I want my government to at least act like it doesn't, or try its best to act like it doesn't, and maybe one day we'll get there too.
I just want to thank you for the opportunity to be here with you. It's been a stimulating conversation for me, and I appreciate your attention and your interest. We're a wonderful society that can be made better by conversations like this and by the dedication of people to work collectively toward solving our problems, whether they are, touch on race or not. And the questions of race, to me, are wrapped up in a very complex set of historical, economic, sociological factors and situations, and there are no easy solutions. But I think as long as we, as a country, with tolerance and humility and steadfastness, work towards solutions, we will get to a more perfect union. So thank you for having me here.
All right, let's thank both of them.